Welcome everyone to the next instalment of BLM's vlogs on the care sector and COVID-19. What does the future look like? This vlog is going to discuss breaches of human rights. I'm Chris Dexter, one of the partners in the healthcare team, and I specialise in defending care homes and care providers against claims brought against them in clinical negligence and as breaches of the Human Rights Act. I'm joined on this vlog by my healthcare team colleague Holly Patterson, who is a solicitor and assists me with the representation of care providers. Hi there, Holly.
Hi, Chris.
During this vlog, we're going to provide you with a quick run through of the potential types of claims that you could see brought against care providers as alleged breaches of the Human Rights Act. Following the number of deaths that have occurred in care homes due to COVID-19, we can see that in the near future, there is a risk that those exposed to the virus in a care setting or bereaved family members will bring claims for alleged breaches of articles of the Human Rights Act in an attempt to right the wrongs that may have occurred and to seek compensation which may not be available to them in a more traditional breach of duty claim in clinical negligence. So to start us off, Holly, which articles of the Human Rights Act do you think loved ones will allege to have been breached?
So there are three main articles of the Human Rights Act which can be used to challenge a wrong. Article 2, the right to life. Article 3, prohibition of torture. And Article 8, the right to family life. You can also sometimes see alleged breaches of Article 14, which is the right to protection from discrimination. The majority of cases that we expect that will be brought as a result of people contracting COVID-19 will be under Article 2, the right to life, following a loved one's death. But first, you need to work out whether the person bringing the claim has the necessary legal standing to do so.
Exactly. You'd think that'd be a relatively straightforward thing to do, but there's been a lot of case law on the subject, and the claimant needs to show if they are a victim for the purposes of the HRA. If the person who's making the claim is the one who contracted COVID-19, then it's more likely than not that they're going to be the victim and will be able to bring that case. However, this becomes more complex when someone's bringing the case on behalf of the deceased following their death from COVID-19. That indirect victim needs to show that they've got sufficient legal and family relationship to the person who suffered as a result of the alleged breach of the HRA, and the personal ties between the person who suffered the breach and the claimant will need to be carefully considered.
This will usually be done on a case-by-case basis.
That's right. So in a care setting, we'd also need to look at whether the care is being provided by a public authority. This is as an alleged breach of the HRA can only be brought against a public authority.
What counts as a public authority for the purposes of the Human Rights Act is quite wide. If, for example, the care home where the person contracted COVID-19 lived was exercising functions of a public nature, then the Human Rights Act may well apply.
If it's unclear if the care provider is exercising functions of a public nature, then you may need to look into the funding of the resident's care, so it's not immediately a straightforward task. So assuming that the claimant has suitable legal standing to bring her claim and the care has been provided by a public authority, or the care provider was exercising functions of a public nature, what next?
Next, we need to look more closely at the article that is actually being alleged to have been breached. For the purposes of this vlog, let's look at Article 2.
So with COVID-19, there's clearly going to be a risk to the right to life. It's a deadly disease, we all know about it, and the care provider will also clearly know about it. The reasonable steps to protect life could be, for example, access to PPE, having enough staff to provide the care that was needed, having sufficiently trained staff or suitable systems in place to ensure that reasonable care was being provided.
More recently as well, there may be some issues in connection with the testing done of staff and of care users.
It's clearly rather complex and nuanced as to how these claims are going to be pleaded and who can bring them, but what if there has been a breach of the Human Rights Act? What can the claimant seek to recover?
The main aim, if there's been a breach, is to right the wrong that is happening or that has occurred. To do this, the claimant can seek one or all of the remedies available to them. The options for remedies are either a declaration that there has been a breach of the Act, an apology, confirmation that the systems that were found to be in breach have been changed, which should then hopefully avoid the breach occurring in the future, and also damages.
The claimant can also seek recovery of one or all of those remedies or a combination of them. If there's been an inquest touching the death of a loved one, then the claimant's legal cost of representation at that inquest can also be claimed as part of the claim. It's often that the inquest costs can have the most financial impact, so it's something to watch out for should an allegation of breach of the Human Rights Act be presented to you.
Unfortunately, allegations of alleged breaches of the Human Rights Act are not that straightforward to deal with, and you may find that you also have allegations relating to negligent clinical treatment brought alongside the alleged breaches of the Human Rights Act.
Whilst we appreciate this is a quick vlog and it's not going to be enough to cover all the issues from an HRA claim, we hope that you found this an interesting insight into possible HRA cases as a result of the COVID-19 pandemic. If you'd like to discuss any cases like this with us, please feel free to get in touch. Our contact details can be found at the end of this vlog.